Hello, everyone. I'm Kelly from South Korea. Today, I will talk about sources of international law with the recent war involving the US, Israel, and Iran. You might wonder whether an East Asian country like South Korea has a legal obligation to intervene. To answer this, we need to understand the sources of international law. Let's look at national law first. National law reflects the will of the citizens, starting with a constitution, followed by civil, criminal, and administrative laws, and so on. In contrast, international law is created by international actors such as states or international organizations, largely based on their consent. Its two main sources are treaties and customary international law. First, treaties are explicit agreements between states. Second, customary international law consists of two elements: general practice and opinio juris, or a sense of legal obligation. So, applying this to our original question, does South Korea bear any legal obligation to intervene? South Korea and the US signed the Mutual Defense Treaty in 1953, which entered into force in 1954. Does this treaty automatically force South Korea to intervene in the Middle East? Legally, the answer is no. Article 3 of the treaty strictly limits the obligation to armed attacks in the Pacific area, and the recent conflict falls outside the scope of the treaty. Therefore, an automatic legal intervention is not required. However, reality is more complex. Even without a strict legal obligation, as a strong ally, there is room for South Korea to get involved politically and diplomatically. Law provides the rules, but politics shapes the decisions. Let's keep an eye on where the peace talks lead and when the war officially ends. That's it for today. Thanks for watching.